independently identifying and addressing the same structural conflict is substantial evidence of the legitimacy of that conflict and the reasonableness of the conditions imposed. The court will not substitute its judgment for the convergent institutional judgment of three co-equal bodies on a question each had independent authority and obligations to address. Hence the policy with the Department of War, the Senate's own rules, and the House's own rules. 6. Military service is entirely voluntary. A person who voluntarily enlists in the armed forces of the United States accepts the totality of the legal framework governing that service, including the conflict of interest conditions of the department they seek to join. Voluntary choices carry voluntary consequences. This principle applies with full force regardless of the enlistee's current status as a member of Congress. 7. The speech and debate protection of Article 1, Section 5 of the Constitution, that senators and representatives shall not be questioned in any other place for speech and debate in either chamber, does not extend to the disclosed conditions of executive branch departments that a member voluntarily seeks to join. The protection covers legislative acts. It does not create immunity from the terms of voluntary employment in another branch. The Secretary's determination satisfies the non-arbitrary standard under 5 U.S.C. Section 305, 307, and 311. It applies a published policy to documented facts, gives reasonable written findings, and was issued by the designated exception authority and was issued in the form and within the time frame directed by the court via the order I gave. 9. The board's failure to escalate petitioners' repeated denials from an OSTIC's provost marshal to the secretary at the designated exception authority under policy 007 was an institutional omission that the court notes. The department is directed to revise its exception notification procedures accordingly. This finding does not alter the outcome on the merits. Now, that was a glossary for easy reference of the opinion. And to be clear, I understand it is a lot to take in at one time. It was written over the course of a week and a half, but the full textual decision will be released within the next 24
This is a Fox News special report.
Pending request from the petitioner and respondent if it is needed sooner. However, to note, I will issue a stay of this taking effect for 72 hours as the textual opinion is released. So it will not go into effect right away in its interpretation. It will take, however, effect after 72 hours. Next, because I use a good bit of legal jargon in this, we're going to go over the legal jargon. I'm going to give you a glossary of legal terms. They're provided for you so that you may read the opinion, understand the legal terminology, and understand its precision and roots in law. The glossary goes over these terms as used in the opinion specifically. Affirmed. When a court affirms a decision made by lower authority, it means the court agrees with the decision and lets it stand. In this opinion, the court affirms the Secretary of War's determination, meaning the court finds the Secretary's decision was correct and will not be overturned. Agency action. A formal decision, rule, or made by a government department or agency acting in its official capacity. In this case, the Secretary of War's written determination denying petitioner's exception request is the agency action under review. Arbitrary and capricious. A legal standard used to evaluate whether a government agency's decision was made reasonably. A decision is arbitrary and capricious if it was made without a rational basis, without following the agency's own rules, or without consideration of the relevant facts. Failure to meet this standard will likely see those things overturned. In this case, the court finds the Secretary's determination was not arbitrary and capricious and meets that standard. Canon and statutory construction. A rule of principle that courts use to interpret the meaning of laws when the text is unclear or when two laws appear to conflict. In this opinion, the court applies several canons, including expressio unis, and the principle that specific statutes control over general ones. Chain of command, the hierarchical structure of authority within a military organization in which order flows from higher ranking officers to lower ranking ones, and in which lower ranking members are expected to follow those decisions of those above them. In this case, the chain of command is relevant to whether petitioner was entitled to rely on denials from an 06 officer as final. Concurrent and or simultaneous service. Holding two positions or offices at the same time. The central dispute in this case concerns whether petitioner may simultaneously hold his Senate committee seat and position in the Marine Corps. Conflict of interest. A situation in which a person's duties or obligations in one role are incompatible with their duties or obligations in another role, such that honest and objective performance of both is impossible or compromised. In this case, the structural conflict arises from petitioner's committee oversight of the very department he seeks to join as a service member. Declaratory judgment. A court ruling that formally states the legal rights and obligations of the parties without ordering anyone to do anything or pay anything. Petitioner requested a declaratory judgment that Section 402 is the controlling authority and that Policy 007 is invalid as applied to him. Denied. When a court denies a petition, it means the court refuses to grant what the petitioner asked for. In this opinion, the petition is denied, meaning the petition does not receive the relief he sought. Determination. A formal written decision issued by the designated authority after reviewing a request. In this case, the determination is the Secretary of War's formal written denial of petitioner's exception policy request under Policy 007, dated April 22, 2026. Dicta and or dicta. Statements in a court opinion that are not necessary to the decision and therefore do not carry the force of binding law. Courts sometimes make observations about related legal questions they are not deciding. Those observations are dicta. This opinion's note on the incompatibility clause is dicta. It flags an unresolved question without deciding it. Try not to laugh because these fucking words. Eligibility. The legal qualification to be considered for, appointed to, or hold a position. Eligibility is a threshold question. It determines whether someone may be considered at all. It is distinct from the conditions that govern service once eligibility is established. Escalation. In a military or administrative context, the process of referring an unresolved matter upward through the chain of command or organizational hierarchy to a higher authority. In this case, the 06's failure to escalate petitioner's exception request to the Secretary is the procedural omission the court addresses. Exception request. A formal application asking a designated authority to exempt the applicant from a rule or policy that would otherwise apply to them. Petitioner submitted an exception request asking the Secretary of War to exempt him from Policy 007 conflict of interest restrictions. Exhaustion of remedies. A legal requirement that a person must use all available internal processes within a government agency before bringing a challenge to court. In this case, the court addresses whether petitioner properly exhausted the department's exception process before seeking judicial review. Expressio unis est exclusio alteris, a Latin phrase meaning the expression of one thing implies the exclusion of others. It is a canon of statutory construction. When a law lists specific items, courts may infer that items were not listed and intentionally excluded. Petitioner argues that because Section 402 lists 3 specific restrictions, no additional restrictions are permitted. The court rejects this argument as applied to conflict of interest conditions on simultaneous service. Final agency action. The last and decisive formal act of government agency on a matter, which triggers the right to seek judicial review in court. An applicant generally cannot ask the court to review a government decision until that decision is final. In this case, the Secretary's written determination is the final agency action. First impression. A legal question no court in this jurisdiction has previously decided. A case of first impression requires the court to establish new legal principles rather than apply existing ones. This case presents a question of first impression regarding the relationship between Section 402 and Departmental Conflict of Interest Authority. General authorization. The opening provision of 2 United States Code Section 402, which states that any sitting member of Congress shall be eligible for employment within executive branch department, notwithstanding Executive Order 108.
She's still the one for you.
And Cialis for daily use helps you be ready anytime the moment is right. Cialis is also the only daily ED tablet approved to treat symptoms of BPH, like needing to go frequently. Tell your doctor about all your medical conditions and medicine.